Question 1. The control framework reveals that a financial advisor in Alabama is managing a portfolio for a client who has substantial holdings in several companies that are demonstrably non-compliant with key European Union data privacy and environmental directives. The advisor is aware of these violations. What is the most responsible course of action for the Alabama-based advisor? Option A. Inform the client that since the advisor and client are based in Alabama, EU directives have no bearing on their investment decisions and continue to manage the portfolio as is. Option B. Focus solely on the current profitability of the investments and refrain from mentioning the EU directive violations to the client, as it might cause unnecessary concern. Option C. Advise the client on the potential legal, financial, and reputational risks associated with investing in companies that violate EU directives and explore alternative compliant investment options. Option D. Recommend that the client move these investments to other jurisdictions or entities that are also known to be non-compliant with various international regulations to avoid scrutiny. Correct answer is C. Advise the client on the potential legal, financial, and reputational risks associated with investing in companies that violate EU directives, and explore alternative, compliant investment options. Explanation. The control framework reveals a situation where a financial advisor in Alabama is presented with a client who has significant investments in companies that are known to be in violation of key European Union directives, specifically concerning data privacy, like the GDPR, and environmental standards. The challenge lies in balancing the client's financial interests with the ethical and regulatory obligations of the advisor, particularly concerning the potential for reputational damage and future legal repercussions for the client and the firm, even though the advisor is based in Alabama and the client's direct operations are not within the EU. The advisor must navigate the complexities of advising on investments that, while potentially profitable, are linked to non-compliant entities within a major global regulatory bloc. The best approach involves proactively advising the client on the risks associated with these investments. This means clearly articulating the potential legal, financial, and reputational consequences of investing in companies that are non-compliant with EU directives. The advisor should explain that even though the client is not directly operating within the EU, investing in entities that violate EU law can expose the client to secondary sanctions, reputational damage, and potential divestment pressures from institutional investors or public opinion. This approach aligns with the ethical duty of care and the principle of acting in the client's best interest by providing comprehensive risk assessment, even for risks that are not immediately apparent or directly within the advisor's immediate regulatory jurisdiction. It also implicitly acknowledges the interconnectedness of global financial markets and the far-reaching impact of major regulatory frameworks like those in the EU. An incorrect approach would be to dismiss the EU directive violations as irrelevant to an Alabama-based client. This fails to recognize the global nature of financial markets and the potential for indirect consequences. Investing in non-compliant entities can lead to reputational harm, making it difficult for the client to access future capital or partnerships, and could also attract scrutiny from U.S. regulators concerned with money laundering or sanctions evasion, even if not directly related to the EU directives themselves. Another incorrect approach is to focus solely on the immediate profitability of the investments without disclosing the associated risks. This violates the fiduciary duty to act in the client's best interest and to provide full and fair disclosure of all material information. Ignoring the regulatory non-compliance of underlying companies is a dereliction of professional responsibility, as it exposes the client to unforeseen liabilities and potential losses. Finally, suggesting the client move assets to entities that are also known to be non-compliant with other regulations, or to engage in complex, opaque structures to obscure the nature of the investments, would be highly unethical and potentially illegal. This approach actively seeks to circumvent regulatory scrutiny and demonstrates a disregard for both ethical principles and legal compliance, potentially exposing both the client and the advisor to severe penalties. Professionals should approach such situations by first identifying all potential risks, both direct and indirect, associated with an investment. This includes understanding the regulatory environment of the companies in which the client is invested, even if that environment is outside their primary jurisdiction. A thorough risk assessment should then be communicated clearly and comprehensively to the client, along with a discussion of alternative, compliant investment strategies, transparency, ethical conduct, and a commitment to the client's long-term well-being, even when it involves difficult conversations about risk, are paramount. Question 2. The control framework reveals that a client operating within Alabama's financial services sector is concerned about potential impacts on their operations stemming from a recent accession treaty ratified by the United States. As a legal advisor in Alabama, how should you ethically and legally approach advising this client regarding the treaty's potential effect on existing Alabama financial regulations? Option A. Assume the accession treaty automatically invalidates all existing Alabama financial regulations that appear to be in conflict with its terms, without further detailed examination. Option B. Recommend that the client ignore the accession treaty's implications, as state laws generally take precedence over international agreements in domestic matters. Option C. Advise the client that Alabama's financial regulations are independent and unaffected by any international treaty, unless specifically amended by the Alabama legislature. Option D. Conduct a detailed analysis of the accession treaty's provisions and its implementing federal legislation to determine the precise scope of its impact on Alabama's regulatory framework, advising the client on any necessary adjustments to comply with federal law. The correct answer is D. Conduct a detailed analysis of the accession treaty's provisions and its implementing federal legislation to determine the precise scope of its impact on Alabama's regulatory framework, advising the client on any necessary adjustments to comply with federal law. Explanation. The control framework reveals a complex ethical dilemma for a legal advisor in Alabama concerning the implications of accession treaties on existing state law. The scenario is professionally challenging because it requires navigating the potential conflict between the supremacy of federal law, which incorporates international treaty obligations, and the specific regulatory landscape of Alabama. The advisor must provide guidance that is both legally sound and ethically responsible, ensuring compliance with all applicable legal principles without overstepping the bounds of state authority or misinterpreting federal preemption. Careful judgment is required to balance the interests of the client with the broader legal and ethical obligations. The best professional approach involves a thorough analysis of the specific accession treaty's provisions and how they are implemented through federal legislation. This approach correctly recognizes that once a treaty is ratified by the United States, it becomes the supreme law of the land, superseding any conflicting state laws. The advisor must then determine if the treaty, as implemented, directly impacts Alabama's specific regulatory framework, or if it requires state action for full effect. This requires consulting the treaty text, relevant federal statutes, and any implementing regulations, and then advising the client on the precise scope of the impact on Alabama law. This aligns with the ethical duty to provide accurate and comprehensive legal advice. Respecting the hierarchy of laws in the United States, an incorrect approach would be to solely focus on Alabama state law without considering the supremacy of federal law and ratified treaties. This fails to acknowledge that international obligations undertaken by the federal government can directly or indirectly alter the legal landscape within Alabama. Such an approach risks providing incomplete or misleading advice, potentially leading the client into non-compliance with federal law. Another incorrect approach would be to assume that any international treaty automatically invalidates all conflicting state laws without a detailed examination of the treaty's specific terms and its federal implementation. This oversimplification ignores the nuances of treaty interpretation and the process by which international law is integrated into domestic law. It could lead to an unwarranted conclusion of invalidity for state laws that are, in fact, still applicable or have been harmonized. A further incorrect approach would be to advise the client to disregard the treaty's implications entirely, arguing that state law remains paramount. This is ethically and legally untenable, as it promotes a disregard for federal law and international commitments, which can have significant legal and reputational consequences. Professionals should employ a decision-making framework that begins with identifying the core legal issue, the interaction between an international treaty and state law. This requires a systematic review of the treaty's text, its ratification process, and any subsequent federal legislation or judicial interpretation. The advisor must then assess the degree of preemption or the need for state-level action. Ethical considerations, such as the duty of competence and diligence, mandate a thorough and accurate analysis. When in doubt, seeking specialized expertise or consulting relevant government agencies is a prudent step. The ultimate goal is to provide advice that is legally compliant, ethically sound, and practically actionable for the client. Question 3. Process analysis reveals that a legal advisor based in Alabama is representing a client whose business operations involve significant trade with companies located within the European Union. The client is seeking advice on compliance with certain product safety standards that appear to be influenced by recent directives originating from the European Union. The advisor, while proficient in Alabama law, has limited direct experience with EU legal frameworks and the specific role of the Court of Justice of the European Union, CJU. What is the most appropriate course of action for the Alabama-based legal advisor to ensure accurate and compliant advice regarding these EU-influenced product safety standards? Option A. Advise the client that EU law is not directly applicable in Alabama, and therefore the client need only comply with Alabama state and federal regulations. Option B. Prioritize advice solely based on Alabama state law, as the advisor's primary jurisdiction and expertise lie within the state's legal system. Option C. Independently interpret the EU directives based on general legal principles, assuming their intent aligns with common international trade practices. Option D. Research and consult authoritative sources of CJU jurisprudence and EU legal texts to understand how these rulings and directives apply to the client's situation, and seek specialized EU legal counsel if necessary. The correct answer is D. Research and consult authoritative sources of CJU jurisprudence and EU legal texts to understand how these rulings and directives apply to the client's situation, and seek specialized EU legal counsel if necessary. Explanation. Scenario analysis. This scenario presents a professional challenge for a legal advisor in Alabama who is tasked with interpreting and applying European Union law. The core difficulty lies in navigating the distinct legal systems and the specific role of the Court of Justice of the European Union, CJU, within the EU framework, while operating under Alabama's jurisdiction. Misunderstanding the CJU authority or its relationship with national courts can lead to incorrect legal advice, potentially causing significant financial and legal repercussions for clients. The advisor must demonstrate a nuanced understanding of how EU law, as interpreted by the CJU, interacts with national legal orders, even when the advisor is based in a jurisdiction that is not an EU member state. Correct approach analysis. The best professional approach involves recognizing that while Alabama is not an EU member, its businesses or individuals may still be subject to EU regulations due to extraterritorial application or specific international agreements. Therefore, the advisor must consult authoritative sources for CJU jurisprudence and EU legal texts. This approach correctly identifies the CJU as the ultimate interpreter of EU law and acknowledges that its rulings are binding within the EU legal order. The advisor should then analyze how these rulings might indirectly or directly affect their Alabama-based clients' operations or interests, seeking clarification from EU legal experts if necessary. This demonstrates a commitment to accurate legal interpretation and client protection by respecting the established hierarchy and interpretive authority of the CJU within its sphere of competence. Incorrect approaches analysis. One incorrect approach is to dismiss the relevance of CJU rulings entirely, assuming that because Alabama is not an EU member, EU law has no bearing. This fails to acknowledge the globalized nature of commerce and the potential for EU regulations to impact businesses operating internationally. Such an approach risks providing incomplete or misleading advice, exposing the client to legal risks. Another incorrect approach is to attempt to interpret CJU rulings independently without consulting official EU legal databases or seeking expert advice. This can lead to misinterpretations of complex legal reasoning and the nuances of EU law, potentially resulting in flawed legal strategies. Finally, an approach that prioritizes Alabama state law over binding CJU interpretations in situations where EU law is demonstrably applicable would be a significant ethical and legal failing, as it disregards the established legal authority of the CJU in matters of EU law. Professional reasoning. Professionals facing such cross-jurisdictional legal questions should adopt a framework of diligent inquiry and respect for established legal authorities. This involves 1. Identifying the potential applicability of foreign law, in this case, EU law to the client's situation. 2. Ascertaining the authoritative interpretive body for that foreign law, the CJU for EU law. 3. Consulting primary legal sources and authoritative interpretations from that body. 4. Seeking specialized expertise when the matter is complex or outside the professional's direct knowledge base. 5. Prioritizing accurate and comprehensive advice that safeguards the client's legal and financial interests, even if it requires engaging with unfamiliar legal systems. Question 4. The performance metrics show a significant surge in sales for a newly launched product line in Germany, driven by aggressive sales tactics. An internal review indicates that the sales team's substantial bonuses are directly linked to exceeding ambitious targets, potentially leading to incomplete disclosure of product limitations to consumers. Considering the principles enshrined in the Treaty on the Functioning of the European Union (TFUE) concerning fair market practices and consumer protection, what is the most ethically and legally sound course of action for the company? Option A. Defend the sales tactics as aggressive but legitimate marketing, asserting that consumers bear the primary responsibility for their purchasing decisions and that TFUE principles are not being violated. Option B. Immediately halt the aggressive sales practices and initiate a comprehensive review of the sales incentive structure to ensure compliance with TFUE principles and consumer protection standards. Option C. Immediately discontinue the product line to avoid further complications, without a thorough investigation into the sales practices or the incentive structure. Option D. Continue the current sales practices, making only minor adjustments to the bonus amounts to slightly reduce the incentive for aggressive tactics, while defending the sales team's performance. The correct answer is B. Immediately halt the aggressive sales practices and initiate a comprehensive review of the sales incentive structure to ensure compliance with TFUE principles and consumer protection standards. Explanation. The performance metrics show a significant increase in sales for a new product line launched in Germany, exceeding initial projections. However, internal audits reveal that the sales team has been incentivized with substantial bonuses tied to exceeding these targets, leading to aggressive sales tactics that may not fully disclose potential product limitations to consumers. This scenario is professionally challenging because it pits the pursuit of financial success against the ethical obligation to ensure fair consumer practices and adherence to EU consumer protection laws, particularly those derived from the Treaty on the Functioning of the European Union (TFUE), concerning market integrity and consumer welfare. The best approach involves immediately halting the aggressive sales practices and initiating a comprehensive review of the sales incentive structure. This approach is correct because it prioritizes consumer protection and regulatory compliance, which are fundamental tenets of TFUE principles aimed at ensuring a well-functioning internal market. Specifically, Article 101 TFUE prohibits agreements that restrict competition, and while not directly an anti-competitive agreement, aggressive sales tactics that mislead consumers can distort market competition by creating an unfair advantage. Furthermore, Article 102 TFUE addresses abuses of dominant position, and while not applicable here, the spirit of fair market operation underpins TFUE. The EU's commitment to a high level of consumer protection, Article 12 TFUE, necessitates that sales practices are transparent and do not exploit consumer vulnerabilities. By pausing the practices and reviewing incentives, the company demonstrates a commitment to ethical conduct and regulatory adherence, mitigating potential legal repercussions and reputational damage. An incorrect approach would be to continue the current sales practices, while only marginally adjusting the incentive structure to slightly reduce the bonus amounts. This is professionally unacceptable because it fails to address the root cause of the aggressive tactics and the potential for consumer harm. It implicitly condones the misleading practices by not stopping them outright and suggests a superficial attempt at compliance rather than a genuine commitment to ethical sales. This approach risks violating TFUE principles by continuing to distort market fairness and potentially misleading consumers, which can lead to investigations and penalties from German and EU authorities. Another incorrect approach would be to defend the sales tactics as merely aggressive marketing, arguing that the sales team is simply performing well and that consumers are responsible for their purchasing decisions. This is professionally unacceptable, as it ignores the ethical implications of potentially misleading consumers and disregards the spirit of TFUE provisions that aim to create a level playing field and protect consumers within the internal market. Such a stance demonstrates a lack of understanding of the broader regulatory and ethical landscape, and could be interpreted as a deliberate attempt to circumvent consumer protection obligations. A final incorrect approach would be to immediately terminate the product line without investigating the sales practices or the incentive structure. While seemingly decisive, this is professionally unacceptable because it punishes the product and potentially innocent employees without a proper understanding of the issue. It fails to address the systemic problem of the incentive structure and the sales tactics, which could reappear with other products. This approach is not aligned with the TFU goal of fostering a dynamic internal market and responsible business conduct. Professionals should adopt a decision-making framework that prioritizes ethical considerations and regulatory compliance. This involves 1. Identifying potential ethical and legal risks associated with business practices. 2. Seeking to understand the underlying causes of problematic behavior, such as flawed incentive structures. 3. Taking immediate corrective action to cease any harmful practices. 4. Conducting thorough reviews to ensure long-term compliance and ethical conduct. 5. Engaging with relevant stakeholders, including legal and compliance departments, to develop robust policies and procedures. Question 5. Risk assessment procedures indicate that a client operating in Alabama may be significantly impacted by a newly enacted European Union directive concerning data privacy. As a legal advisor, what is the most appropriate method to determine the directive's legal standing and implications for the client, considering the foundational principles of EU law? Option A. Focus exclusively on the detailed text of the new EU directive, assuming its provisions are directly applicable and self-executing, without further consideration of its relationship to the foundational EU treaties. Option B. Consult secondary legal commentary and non-EU legal analyses to gain an understanding of the directive, without directly examining the EU treaties or the directive's legislative history. Option C. Treat the directive as a standalone piece of legislation, prioritizing any informal guidance or interpretations from industry associations over the formal legal framework established by the EU treaties and the directive itself. Option D. Analyze the specific provisions of the EU treaties, such as the Treaty on European Union and the Treaty on the Functioning of the European Union, to understand the legal basis and scope of the directive and how it aligns with the overarching objectives and powers established by these primary sources of EU law. The correct answer is D. Analyze the specific provisions of the EU treaties, such as the Treaty on European Union and the Treaty on the Functioning of the European Union, to understand the legal basis and scope of the directive, and how it aligns with the overarching objectives and powers established by these primary sources of EU law. Explanation. Scenario analysis. This scenario presents a professional challenge for a legal advisor in Alabama who is tasked with advising a client on the implications of a new European Union directive. The challenge lies in accurately interpreting and applying the principles of EU law, specifically how treaties function as primary sources, within the context of a client's business operations that may be affected by this directive. The advisor must navigate the potential for conflicting interpretations and ensure the advice is grounded in the foundational principles of EU law, avoiding misapplication or oversimplification. Careful judgment is required to distinguish between binding treaty obligations and secondary EU legislation, and to understand how the former informs the latter. Correct approach analysis. The best professional practice involves a thorough examination of the relevant EU treaties, such as the Treaty on European Union (TEU) and the Treaty on the Functioning of the European Union (TFU), to understand their foundational principles and how they empower the EU institutions to enact directives. This approach correctly recognizes that treaties are the primary, foundational sources of EU law, establishing the legal basis, objectives, and institutional framework of the Union. Directives, while binding, are secondary legislation derived from the powers granted by these treaties. Therefore, understanding the treaty provisions that underpin the directive is crucial for accurate interpretation and application, ensuring the client's compliance is based on the highest order of EU law. This aligns with the principle that all EU law must be consistent with its foundational treaties. Incorrect approaches analysis. One incorrect approach involves focusing solely on the text of the new EU directive without considering the underlying treaty provisions. This fails to acknowledge the hierarchical nature of EU law, where treaties stand above directives. Such an approach risks misinterpreting the directive's scope or intent, as its application is ultimately constrained by the powers and principles established in the TEU and TFEU. It overlooks the possibility that the directive might be ultra vires, or that its interpretation should be guided by broader treaty objectives. Another incorrect approach is to treat the directive as if it were a self-executing piece of legislation directly enforceable in Alabama courts, without considering the necessary transposition into national law. While EU directives are binding, they require member states to achieve a certain result, leaving the choice of form and methods to national authorities. This approach ignores the crucial step of national implementation, which is a fundamental aspect of how EU law, including directives, becomes effective within member states. A further incorrect approach is to rely on interpretations or guidance from non-EU legal sources or academic commentary that does not directly reference the foundational EU treaties. While such sources can offer insights, they do not possess the legal authority of the treaties themselves. This approach risks adopting interpretations that are not legally sound or that do not reflect the authoritative understanding of the treaties as primary sources of EU law, potentially leading to flawed advice. Professional reasoning. Professionals in this situation should adopt a systematic approach to legal analysis. This begins with identifying the relevant legal sources, prioritizing them according to their hierarchy within the specified jurisdiction, in this case, EU law. For EU law, this means starting with the foundational treaties. The next step is to analyze how secondary legislation, like directives, is derived from and constrained by these treaties. Professionals should then consider the specific provisions of the directive and how they are intended to be implemented, paying close attention to any requirements for national transposition. Finally, they should cross-reference their interpretation with established case law of the Court of Justice of the European Union, which plays a vital role in interpreting EU law, including the treaties. This structured approach ensures that advice is legally robust, compliant with the hierarchy of laws, and ethically sound. Question 6. The control framework reveals that a large manufacturing company operating across multiple member states of the European Union is considering implementing a tiered pricing strategy for its products. The marketing department proposes charging significantly higher prices in certain member states compared to others, arguing that this will maximize profits by exploiting differences in consumer purchasing power and market elasticity. The internal legal team, while acknowledging the potential profitability, has expressed some reservations about the strategy's compatibility with EU competition law and the principle of non-discrimination. As the compliance officer for the European operations, you are tasked with advising on the appropriate course of action. Option A. Implement the tiered pricing strategy, but only in those member states where enforcement of EU competition law is perceived to be less stringent, to minimize the risk of penalties. Option B. Advise the marketing department to abandon the tiered pricing strategy immediately due to the internal legal team's reservations, without conducting further detailed legal analysis. Option C. Seek external legal counsel specializing in EU competition law to conduct a comprehensive assessment of the proposed pricing strategy's legality under EU regulations and advise on potential risks and mitigation strategies. Option D. Proceed with the tiered pricing strategy, relying on the internal legal team's assessment, and implement it in all member states where it is deemed most profitable, assuming that market differences justify the approach. Correct answer is C. Seek external legal counsel specializing in EU competition law to conduct a comprehensive assessment of the proposed pricing strategy's legality under EU regulations and advise on potential risks and mitigation strategies. Explanation. The control framework reveals a common ethical dilemma faced by compliance officers in multinational corporations operating within the European Union. The challenge lies in balancing the company's commercial interests with the overarching principles of EU law, particularly concerning the free movement of goods and services and the prohibition of discriminatory practices. The scenario is professionally challenging because it requires a nuanced understanding of EU legal principles and the ability to apply them to a complex business situation where a direct conflict of interest exists. The compliance officer must navigate potential legal repercussions for the company, reputational damage, and their own professional integrity. The best approach involves a thorough legal analysis of the proposed discriminatory pricing strategy against the backdrop of EU competition law and the Treaty on the Functioning of the European Union (TFEU). This approach prioritizes adherence to fundamental EU legal principles, such as Article 101 TFU, prohibiting anti-competitive agreements, and Article 102 TFU, prohibiting abuse of dominant position, as well as the principle of non-discrimination enshrined in Article 18 TFU. By seeking independent legal counsel specializing in EU competition law, the compliance officer ensures that the company's actions are assessed against the most stringent legal standards. This proactive step demonstrates a commitment to upholding EU law, mitigating legal risks, and safeguarding the company's long-term interests by avoiding potentially illegal and harmful practices. An approach that involves implementing the pricing strategy while relying solely on internal legal advice, which may be influenced by commercial pressures, is professionally unacceptable. This fails to adequately consider the potential for the strategy to violate EU competition law, such as engaging in price discrimination that distorts competition within the internal market. Such a failure could lead to significant fines, legal challenges, and reputational damage. Another professionally unacceptable approach is to dismiss the concerns raised by the marketing department without a comprehensive legal review. This demonstrates a disregard for the potential implications of the proposed strategy under EU law and a failure to exercise due diligence. It prioritizes short-term commercial gains over legal compliance and ethical conduct. Finally, an approach that suggests proceeding with the strategy, but only in countries where enforcement is perceived to be less rigorous, is also professionally unacceptable. This demonstrates a cynical and opportunistic interpretation of EU law, attempting to exploit perceived loopholes rather than adhering to the spirit and letter of the law across the entire EU internal market. This approach undermines the fundamental principles of legal certainty and equal application of law within the Union. Professionals should adopt a decision-making process that begins with identifying potential legal and ethical conflicts. This should be followed by a thorough investigation, including seeking expert legal advice when necessary, to understand the implications of different courses of action. The decision should then be made based on a clear commitment to upholding relevant legal frameworks and ethical principles, prioritizing long-term sustainability and compliance over short-term gains. Question 7. The evaluation methodology shows that an Alabama-based technology firm is seeking to expand its services into the German market. The firm's legal counsel has identified several EU regulations and directives that appear relevant to their service offerings. What is the most appropriate and legally sound method for the firm to ensure compliance with this EU secondary legislation? Option A. Rely on general advice provided by an Alabama-based industry association regarding common compliance challenges for technology firms operating internationally. Option B. Assume that if the specific EU regulations and directives have not been explicitly enacted into Alabama state law, they do not impose any direct obligations on the firm. Option C. Focus exclusively on understanding EU directives and disregard EU regulations, as directives are perceived as more impactful on business operations. Option D. Conduct a thorough review of the official EU legal databases, your LEX, to ascertain the precise wording and applicability of the relevant EU regulations and directives, and research their transposition status in Germany. The correct answer is D. Conduct a thorough review of the official EU legal databases, your LEX, to ascertain the precise wording and applicability of the relevant EU regulations and directives, and research their transposition status in Germany. Explanation. The evaluation methodology shows a scenario that is professionally challenging due to the inherent complexity and evolving nature of secondary legislation within the European Union, particularly as it applies to Alabama businesses operating within the EU market. The challenge lies in accurately identifying, interpreting, and implementing regulations that may not be directly enacted by the Alabama legislature, but have direct or indirect impact on Alabama-based entities. This requires a nuanced understanding of how EU directives and regulations are transposed into national law and how they affect business operations, compliance, and market access. Careful judgment is required to ensure that Alabama businesses remain compliant with EU standards without overstepping their legal obligations or misinterpreting the scope of EU law. The correct approach involves a proactive and meticulous review of official EU legal databases and guidance documents, cross-reference with any relevant Alabama state laws or interpretations that address the implementation of EU regulations. This entails understanding that EU secondary legislation, such as directives and regulations, creates binding obligations. Directives require member states to achieve a certain result, leaving the choice of form and methods to national authorities, meaning their impact can vary depending on how they are transposed into national law. Regulations, on the other hand, are directly applicable in all member states. Therefore, a thorough examination of the specific EU legal instrument and its transposition status in relevant EU member states is crucial. This approach ensures that Alabama businesses are adhering to the precise requirements of EU law, minimizing the risk of non-compliance, penalties, and reputational damage. It prioritizes accuracy and direct engagement with the source of the legal obligation. An incorrect approach would be to rely solely on general industry advice or interpretations from non-official sources. This is professionally unacceptable because it introduces a significant risk of misinterpretation or outdated information. Industry advice, while potentially helpful, is not legally binding and may not fully capture the nuances of EU legal texts. Similarly, relying on interpretations from sources that are not official EU or member state legal bodies can lead to significant compliance failures. This approach bypasses the direct regulatory framework, potentially leading to a misunderstanding of the scope, application, and enforcement mechanisms of EU secondary legislation. Another incorrect approach is to assume that if a particular EU regulation has not been explicitly mirrored in Alabama state law, it does not apply. This is a critical failure because EU regulations are directly applicable in EU member states, and their impact on businesses operating within the EU market is independent of specific state-level legislative action in Alabama. Alabama businesses engaging in trade or having operations within the EU are subject to EU law, regardless of whether Alabama has enacted specific legislation to implement it. This approach demonstrates a fundamental misunderstanding of the extraterritorial reach of EU law for businesses operating within its jurisdiction. A third incorrect approach is to only consider EU directives and ignore EU regulations. This is flawed because both directives and regulations constitute secondary legislation with binding force, albeit through different mechanisms. While directives require transposition, regulations are directly applicable. Ignoring one category of secondary legislation means a significant portion of potential legal obligations is overlooked, leading to incomplete compliance. The professional reasoning process for similar situations should involve a systematic approach. First, identify the specific EU legal instruments, directives, and regulations that are relevant to the business's operations or market. Second, consult official EU legal resources, e.g., your lex, to understand the exact text and status of these instruments. Third, research how these instruments have been transposed into the national laws of the relevant EU member states where the business operates or trades. Fourth, seek advice from legal counsel specializing in EU law if there is any ambiguity or complexity. Finally, implement the identified compliance measures diligently and establish a process for ongoing monitoring of changes in EU secondary legislation. Question 8. What factors should the European Commission prioritize when initially assessing a potential infringement of European Union law by a member state, such as Germany, concerning its national regulations on renewable energy subsidies, to determine if formal proceedings under Article 258 TFU are warranted? Option A. A narrow interpretation of a single article within the relevant EU directive, focusing solely on its most restrictive possible meaning in isolation from other provisions in the factual context. Option B. A deferral of any assessment until political relations with Germany improve, regardless of the apparent severity of the potential breach. Option C. A comprehensive review of all available evidence, including national legislation, administrative practices, and relevant case law, to establish a prima facie case of non-compliance with specific EU directives and regulations. Option D. An immediate issuance of a letter of formal notice based on preliminary concerns raised by a single advocacy group, without extensive internal verification. The correct answer is C. A comprehensive review of all available evidence, including national legislation, administrative practices, and relevant case law, to establish a prima facie case of noncompliance with specific EU directives and regulations. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of the European Union's infringement proceedings framework, specifically concerning the preliminary assessment of potential violations of EU law by a member state. The core difficulty lies in balancing the need to address potential breaches with the procedural safeguards afforded to member states and the principle of subsidiarity. A careful judgment is required to determine the appropriate initial steps without prematurely escalating the situation or overlooking significant issues. The best professional approach involves a thorough, evidence-based preliminary assessment of the alleged infringement. This entails meticulously gathering and analyzing all relevant documentation, legal provisions, and factual circumstances pertaining to the member state's actions or inactions. The objective is to establish a prima facie case that a specific provision of EU law has likely been violated. This approach is correct because it aligns with the procedural requirements outlined in Article 258 of the Treaty on the Functioning of the European Union (TFU). This article mandates that the European Commission, before initiating formal proceedings, must conduct an investigation to ascertain whether a member state has failed to fulfill an obligation under the treaties. This preliminary phase is crucial for ensuring that infringement actions are well-founded, proportionate, and respect the principle of legal certainty. It allows the Commission to engage in a dialogue with the member state based on concrete evidence, fostering a more collaborative resolution where possible. An incorrect approach would be to immediately issue a formal letter of formal notice based on initial suspicions or anecdotal evidence, without conducting a comprehensive preliminary investigation. This fails to meet the evidential threshold required by Article 258 TFU and bypasses the essential investigative step. It risks initiating proceedings on weak grounds, potentially leading to unnecessary legal battles, reputational damage for the Commission, and a misallocation of resources. Ethically, it undermines the principle of due process for the member state. Another incorrect approach would be to delay any action indefinitely due to political considerations or a reluctance to confront a member state, even when there is substantial evidence of a breach. This inaction constitutes a failure to uphold the Commission's role as guardian of the treaties, as stipulated in Article 17 of the Treaty on European Union (TEU). It allows potential breaches of EU law to persist, harming the integrity of the internal market and potentially disadvantaging other member states or individuals. This approach is ethically problematic, as it neglects the Commission's duty to ensure the uniform application of EU law across all member states. A final incorrect approach would be to rely solely on the interpretation of a single, isolated legal provision, without considering its broader context within the EU legal order or the specific factual matrix of the alleged infringement. This narrow focus can lead to misinterpretations of EU law and an inaccurate assessment of whether a breach has occurred. It fails to acknowledge the interconnectedness of EU law and the importance of a holistic understanding when evaluating compliance. This approach lacks the analytical rigor necessary for a sound preliminary assessment and could result in unfounded or misdirected infringement proceedings. The professional decision-making process should involve a systematic approach. First, clearly identify the alleged violation and the relevant EU legal provisions. Second, conduct a thorough and objective investigation, gathering all pertinent evidence. Third, assess the evidence against the legal provisions to determine if a prima facie case of infringement exists. Fourth, if a prima facie case is established, proceed with the formal notification process, providing the member state with a clear explanation of the alleged breaches and the evidence supporting them, thereby allowing for a response and potential rectification. Question 9. The risk matrix shows a potential conflict between a company's established business practices in Alabama and emerging European Union (EU) data privacy regulations, particularly concerning the implications of landmark cases like Schrems Roman II. Given that the company processes personal data of individuals who may be residing in the EU, which of the following approaches best addresses the compliance challenge? Option A. Disregard the implications of the Schrems Roman II ruling, believing it is only relevant to large multinational technology corporations and not to businesses operating in Alabama. Option B. Conduct a transfer impact assessment (TIA) for all data transfers to third countries, evaluate the adequacy of data protection in those countries, and implement supplementary measures where necessary to ensure essentially equivalent protection to that guaranteed by the EU's General Data Protection Regulation (GDPR). Option C. Assume that EU data privacy laws do not apply because the company's primary operations and physical location are in Alabama. Option D. Continue using existing data processing agreements and standard contractual clauses without further assessment, as they were deemed compliant prior to the Schrems Roman II ruling. The correct answer is B. Conduct a transfer impact assessment (TIA) for all data transfers to third countries, evaluate the adequacy of data protection in those countries, and implement supplementary measures where necessary to ensure essentially equivalent protection to that guaranteed by the EU's General Data Protection Regulation (GDPR). Explanation: the risk matrix shows a potential conflict between a company's established business practices in Alabama and emerging European Union (EU) data privacy regulations, particularly concerning the implications of landmark cases like Schrems Roman II. This scenario is professionally challenging because it requires navigating a complex legal and ethical landscape where differing jurisdictional requirements can lead to significant compliance risks and reputational damage. The company must balance its existing operations with the need to adhere to stringent, extraterritorial EU laws, even when its primary operations are within Alabama. Careful judgment is required to interpret the broad implications of EU case law and apply them to specific business activities that may involve processing the data of EU citizens. The best approach involves proactively assessing the company's data processing activities for any connection to EU residents, and, if such connections exist, implementing robust data transfer mechanisms and safeguards that align with the principles established in Schrems Roman II and subsequent EU guidance. This includes conducting transfer impact assessments, TIA, to evaluate the level of data protection in the destination country and implementing supplementary measures where necessary. This approach is correct because it directly addresses the extraterritorial reach of EU data protection law, like the GDPR, and the specific concerns highlighted by the Court of Justice of the European Union, CJU, in Schrems Roman II, regarding government surveillance and the lack of adequate redress mechanisms for individuals. Adhering to these principles ensures compliance with the GDPR, mitigates the risk of significant fines, and upholds the ethical obligation to protect personal data. An incorrect approach would be to assume that because the company's primary operations are in Alabama, EU data privacy laws do not apply. This ignores the extraterritorial scope of the GDPR, which can apply to controllers and processors outside the EU if they offer goods or services to, or monitor the behavior of, individuals in the EU. This failure to recognize the applicability of EU law is a significant regulatory and ethical failure. Another incorrect approach would be to rely solely on existing data processing agreements without considering the specific findings of Schrems Roman II. While standard contractual clauses, SCC, are a valid transfer mechanism, the CJU ruling in Schrems Roman II mandated that parties using SCCs must verify, on a case-by-case basis, whether the law of the third country ensures a level of protection essentially equivalent to that guaranteed within the EU. Simply continuing to use SCCs without this verification process is a regulatory failure. A further incorrect approach would be to disregard the implications of Schrems Roman II entirely, believing that the ruling primarily affects large tech companies and not businesses operating in Alabama. This is a dangerous assumption, as the principles of data protection and the requirements for international data transfers apply broadly. Ignoring these landmark cases can lead to non-compliance and severe penalties. The professional decision-making process for similar situations should involve a continuous cycle of risk assessment, legal interpretation, and proactive compliance. Professionals should 1. Identify all data processing activities, paying close attention to any potential links to individuals in jurisdictions with stringent data protection laws. 2. Stay informed about relevant landmark cases and regulatory guidance from applicable jurisdictions. 3. Conduct thorough legal reviews to understand the extraterritorial reach and specific requirements of foreign laws. 4. Implement and regularly review data transfer mechanisms and safeguards to ensure ongoing compliance. 5. Seek expert legal counsel when navigating complex cross-border data privacy issues. Question 10. The risk matrix shows a potential for member states, in their deliberations within the Council of the European Union concerning a new directive on digital services, to agree on a mechanism for sharing detailed, non-public pricing strategies for their national telecommunications providers. This exchange is intended to harmonize market conditions. If the average annual revenue from telecommunications services in the participating member states is euros 50 billion, and an independent economic analysis estimates that such information sharing, if it leads to a 5% increase in average prices across the board, would result in an annual overcharge to consumers of euros 2.5 billion. What is the primary legal concern under EU law? Option A. The information exchange is a legitimate exercise of member states' sovereign powers within the Council and therefore falls outside the scope of EU competition law. Option B. The information exchange is permissible because it is intended to harmonize market conditions, which is a stated objective of EU directives. Option C. The information exchange is unlikely to restrict competition because the pricing strategies are proprietary and not directly comparable across different national markets. Option D. The information exchange could constitute an agreement that has the object or effect of restricting competition under Article 101(1) TFU, leading to an annual consumer overcharge of euros 2.5 billion, which is incompatible with the internal market. The correct answer is D. The information exchange could constitute an agreement that has the object or effect of restricting competition under Article 101(1) TFU, leading to an annual consumer overcharge of euros 2.5 billion, which is incompatible with the internal market. Explanation. The risk matrix shows a potential breach of Article 101 TFU regarding anti-competitive agreements within the Council of the European Union's legislative process. This scenario is professionally challenging because it requires navigating complex EU competition law principles within the context of intergovernmental decision-making, where political considerations can sometimes obscure legal compliance. The core issue is determining whether the proposed information exchange among member states, facilitated by the Council, constitutes a restriction of competition that is incompatible with the internal market. Careful judgment is required to distinguish between legitimate information sharing for policy coordination and illegal collusion that distorts competition. The best professional approach involves a thorough assessment of the proposed information exchange against the criteria outlined in Article 101(1) TFU. This includes evaluating whether the agreement has the object or effect of preventing, restricting, or distorting competition within the internal market. Specifically, one must consider if the information shared is competitively sensitive, if the participants are actual or potential competitors, and if the exchange is likely to lead to coordinated behavior that harms consumers or other businesses. If the information exchange is deemed to have an anti-competitive object or effect, then the next step is to assess if it can benefit from an exemption under Article 101(3) TFU, which requires that the agreement contributes to improving the production or distribution of goods, or to promoting technical or economic progress, while allowing consumers a fair share of the resulting benefit, and does not impose restrictions which are not indispensable to the attainment of these objectives, nor afford the parties the possibility of eliminating competition in respect of a substantial part of the products in question. In this case, the proposed information exchange, if it leads to price fixing or market sharing among member states' national industries, would clearly violate Article 101 TFU and would not qualify for any exemption. The calculation of potential economic harm, for instance, by estimating the difference between the current market price and a hypothetical competitive price, would be crucial in demonstrating the anti-competitive effect. For example, if the average price of a product in the participating member states is euros 100, and a competitive analysis suggests it would be euros 80 under free competition, the potential overcharge per unit is euros 20. If 1 million units are sold annually across these states, the total annual harm is /1,000,000 units times euros 20/text unit equals euros 20,000,000. This quantitative assessment strengthens the argument for a breach. An incorrect approach would be to assume that any information exchange within the Council's framework is automatically compliant with EU law due to its intergovernmental nature. This fails to recognize that member states, when acting in their economic capacity or influencing economic activities, are subject to competition rules. The justification that the information exchange is for policy coordination is insufficient if the practical outcome is collusion. Another incorrect approach would be to focus solely on the procedural aspects of the Council's decision-making, without analyzing the substantive economic impact of the information exchange. This overlooks the core purpose of Article 101 TFU, which is to protect competition in the internal market, regardless of the forum in which anti-competitive behavior occurs. A further flawed approach would be to dismiss the potential for harm by arguing that the information shared is publicly available. While public information can be used in competition analysis, the context and purpose of its exchange are critical. If the exchange facilitates coordinated behavior that would not otherwise occur, it can still be problematic. The professional reasoning process should involve a structured legal and economic analysis. First, identify the relevant EU law provisions, primarily Article 101 TFU. Second, assess the nature of the agreement or practice, in this case, the information exchange. Third, determine if the agreement has an anti-competitive object or effect, using quantitative economic analysis where appropriate to demonstrate the magnitude of potential harm. Fourth, consider any potential justifications or exemptions under Article 101(3) TFU, rigorously evaluating whether the conditions are met. Finally, conclude on compliance or non-compliance, documenting the analysis and reasoning clearly. Question 11. Quality control measures reveal a misunderstanding among junior policy analysts regarding the specific powers and functions of the European Council within the framework of European Union governance. Considering the Treaty on European Union, which of the following accurately describes the primary role of the European Council in the EU's institutional structure? Option A. To act as the sole legislative body of the European Union, independent of other institutions. Option B. To define the general political direction and priorities of the European Union, providing the necessary impetus for its development. Option C. To directly draft and adopt all legislative acts of the European Union. Option D. To issue legally binding regulations that are immediately enforceable in all member states without further legislative action. The correct answer is B. To define the general political direction and priorities of the European Union, providing the necessary impetus for its development. Explanation. Scenario analysis. This scenario presents a professional challenge in interpreting and applying the European Council's role within the European Union's legislative process, specifically concerning its influence on the direction of EU policy and its interaction with other institutions. Professionals must understand the nuances of interinstitutional dynamics and the Council's specific powers to provide accurate advice or make informed decisions regarding EU law and policy. Misinterpreting the Council's mandate can lead to flawed strategic planning, incorrect legal interpretations, and ultimately, non-compliance or ineffective advocacy. Correct approach analysis. The best professional approach involves accurately identifying the European Council's primary function as setting the general political direction and priorities of the European Union. This includes its role in defining the EU's strategic interests and providing the impetus for legislative action, but not in directly drafting or adopting legislation. This understanding aligns with Article 15 of the Treaty on European Union (TEU), which outlines the European Council's mandate. Professionals must recognize that while the Council guides, the legislative power primarily resides with the European Parliament and the Council of the European Union, acting as co-legislators. Incorrect approaches analysis. One incorrect approach is to assume the European Council directly drafts and adopts EU legislation. This fails to distinguish the European Council's strategic role from the legislative functions of the Council of the European Union and the European Parliament. This misunderstanding would lead to incorrect assessments of legislative processes and the locus of decision-making. Another incorrect approach is to believe the European Council's decisions are legally binding on member states in the same way as directly applicable EU regulations. While the European Council's conclusions set political direction and can lead to subsequent legal acts, they are not, in themselves, primary legislation that creates direct legal obligations for individuals or member states without further legislative action. A further incorrect approach is to consider the European Council as merely an advisory body with no significant influence on policy. This overlooks its crucial role in providing the high-level political impetus and strategic framework that shapes the EU's agenda and influences the legislative work of other institutions. Professional reasoning. Professionals should approach questions regarding EU institutional roles by first identifying the specific institution in question and its defined powers and responsibilities within the EU treaties. They should then consider how this institution interacts with other EU bodies in the legislative and policy-making processes. A systematic review of the relevant treaty articles, e.g., Article 15 TEU for the European Council, and established case law is essential. When faced with ambiguity, seeking clarification from official EU sources or consulting with legal experts specializing in EU law is a prudent step. Question 12. The risk matrix shows a potential merger between two large pharmaceutical companies that operate extensively within the European Union. One company is a dominant supplier of specialized medical equipment to public healthcare providers across several EU member states, while the other is a major producer of generic pharmaceuticals frequently prescribed by physicians in those same healthcare systems. Considering the European Commission's role in regulating competition within the EU, which of the following approaches best addresses the potential anti-competitive implications of this proposed merger? Option A. Accept informal commitments from the merging companies regarding their future market conduct, without requiring legally binding structural or behavioral remedies based on their reputation for compliance. Option B. Focus primarily on the potential cost savings and operational efficiencies that the merger could generate, assuming that these benefits will outweigh any minor shifts in market dynamics within the EU. Option C. Prioritize the assessment of the merger's impact solely within the largest member state where both companies have significant operations, as this will likely reflect the overall competitive landscape. Option D. Conduct a comprehensive analysis of the combined entity's market position in both the medical equipment and generic drug sectors across the entire European Economic Area, assessing potential impacts on pricing, innovation, and consumer choice, and considering the need for remedies to maintain effective competition. The correct answer is D. Conduct a comprehensive analysis of the combined entity's market position in both the medical equipment and generic drug sectors across the entire European Economic Area, assessing potential impacts on pricing, innovation, and consumer choice, and considering the need for remedies to maintain effective competition. Explanation. The risk matrix shows a potential conflict of interest arising from a proposed merger between two major pharmaceutical companies operating within the European Union. One company, PharmaCorp, is a significant supplier of medical devices to public hospitals in Germany, while the other, Meditech, is a leading manufacturer of generic drugs that are frequently prescribed by doctors in those same hospitals. The European Commission's Directorate General for Competition, DG Comp, is responsible for assessing whether such mergers would distort competition within the single market. The professional challenge lies in ensuring that the merger does not create a dominant position that could lead to higher drug prices, reduced innovation, or preferential treatment of one company's products over others, thereby harming consumers and healthcare systems across the EU. Careful judgment is required to balance the potential efficiencies of a merger against the risks of anti-competitive behavior. The best approach involves a thorough and objective assessment of the merger's potential impact on competition, focusing on market definition, market shares, barriers to entry, and the potential for coordinated or unilateral anti-competitive conduct. This includes analyzing the combined entity's market power in both the medical device and generic drug sectors, considering any potential for leveraging dominance in one market to gain an unfair advantage in the other. The European Commission's merger control guidelines, particularly those related to assessing horizontal mergers and potential vertical foreclosure, would be the primary regulatory framework. This approach is correct because it directly addresses the core mandate of DG Comp, to prevent mergers that would significantly impede effective competition in the European Economic Area. It prioritizes consumer welfare and the integrity of the single market by adhering to established competition law principles and analytical tools. An incorrect approach would be to prioritize the potential economic benefits of the merger, such as cost savings and increased efficiency, without adequately scrutinizing the competitive landscape. This might involve downplaying concerns about market concentration or assuming that regulatory oversight will naturally prevent any anti-competitive outcomes. Such an approach fails to meet the regulatory requirement of demonstrating that the merger will not have an adverse effect on competition. Another incorrect approach would be to focus solely on the impact within a single member state, such as Germany, without considering the broader implications for the entire European Union single market. The European Commission's jurisdiction extends across the EEA, and a merger's competitive effects must be assessed on this wider scale. A further flawed approach would be to rely on informal assurances from the merging parties regarding their future conduct, without robust commitments or structural remedies that are legally binding and enforceable under EU competition law. This neglects the Commission's duty to prevent harm to competition proactively. Professionals should adopt a decision-making process that begins with a clear understanding of the relevant EU competition law and the European Commission's merger control procedures. This involves identifying potential competition concerns early, conducting a comprehensive market analysis, and engaging in a rigorous assessment of the merger's likely effects. The process should be guided by the principle of preventing significant impediments to effective competition and should involve seeking appropriate remedies, whether behavioral or structural, to address any identified issues. Transparency and objectivity are paramount throughout the assessment. Question 13. Governance review demonstrates that a national court in Germany is experiencing significant political pressure to interpret a recent preliminary ruling from the Court of Justice of the European Union in a manner that would favor national economic interests, potentially conflicting with the ruling's clear intent. As an EU law advisor, what is the most appropriate course of action to ensure compliance with EU law? Option A. Advise the national court to disregard the CJU ruling altogether, citing the primacy of national constitutional law in this specific instance. Option B. Advise the national court to formally request a preliminary ruling from the Court of Justice of the European Union to clarify any ambiguities and ensure consistent application of the judgment. Option C. Recommend that the national court interpret the CJU ruling in a way that best serves Germany's national economic interests, even if it slightly deviates from the literal wording. Option D. Suggests that the national court delay any definitive interpretation of the ruling until further political discussions at the EU level can provide more guidance. Correct answer is B. Advise the national court to formally request a preliminary ruling from the Court of Justice of the European Union to clarify any ambiguities and ensure consistent application of the judgment. Explanation. Scenario analysis. This scenario presents a professional challenge for a legal advisor working within the European Union framework. The core difficulty lies in balancing the imperative to uphold the integrity of EU law, as interpreted by the Court of Justice of the European Union (CJU), with the potential for national political pressures to influence legal interpretation or implementation. The advisor must navigate the delicate relationship between national courts and the CJU, ensuring that the principle of primacy of EU law is respected, while also acknowledging the distinct roles of different judicial bodies. Careful judgment is required to avoid actions that could undermine the uniform application of EU law across member states. Correct approach analysis. The best professional practice involves formally seeking clarification from the Court of Justice of the European Union. This approach directly addresses the ambiguity by engaging the ultimate arbiter of EU law. It acknowledges the CJU role in ensuring consistent interpretation and application of EU law across all member states, as mandated by Article 267 of the Treaty on the Functioning of the European Union (TFU). This procedure allows the CJU to provide a definitive ruling, which then becomes binding on national courts, thereby resolving the conflict and ensuring compliance with EU law. This upholds the principle of judicial cooperation and the supremacy of EU law. Incorrect approaches analysis. One incorrect approach involves advising the national court to disregard the CJU preliminary ruling due to perceived political expediency or national interest. This directly violates the principle of primacy of EU law and the binding nature of CJU judgments. It undermines the uniform application of EU law and could lead to legal fragmentation within the EU. Such an action would be a serious breach of professional duty and EU regulatory obligations. Another incorrect approach is to advise the national court to interpret the CJU ruling in a manner that subtly aligns with national policy, even if this interpretation deviates from the clear intent of the court. This is a form of indirect noncompliance. While not an outright rejection, it still compromises the uniform application of EU law and erodes the authority of the CJU. It represents a failure to uphold the spirit and letter of EU law. A further incorrect approach is to delay or obstruct the referral of the question to the CJU, hoping the issue will resolve itself or be overtaken by events. This inaction can perpetuate legal uncertainty and potentially lead to continued breaches of EU law by the national entity. It fails to proactively address a clear legal challenge and can be seen as a dereliction of professional responsibility to ensure compliance with EU legal obligations. Professional reasoning. Professionals facing such dilemmas should adopt a structured decision-making process. Firstly, identify the precise legal issue and the relevant EU law. Secondly, determine the role and authority of the Court of Justice of the European Union in interpreting and applying that law. Thirdly, assess the potential consequences of different courses of action, particularly in relation to compliance with EU law and the principle of primacy. Fourthly, consult relevant professional ethical guidelines and legal advice if necessary. Finally, prioritize actions that uphold the integrity and uniform application of EU law, even when faced with national pressures. Engaging with the CJU through the preliminary ruling procedure is the established and legally sound mechanism for resolving interpretative disputes. Question 14. Governance review demonstrates that a multinational corporation with significant operations in Alabama is considering implementing a new employee monitoring system that collects detailed data on employee activity, including keystrokes and website visits. While the company believes this system will enhance productivity and security, it has raised concerns among employees regarding their privacy. The company's legal department is aware that some of its data processing activities might fall under the purview of European Union regulations due to its EU-based subsidiaries. Which of the following approaches best navigates the ethical and legal complexities of this situation, considering the potential applicability of the Charter of Fundamental Rights of the European Union? Option A. Disregard the potential applicability of the Charter of Fundamental Rights of the European Union, asserting that the company's primary operations are in Alabama and therefore only U.S. labor laws apply, proceeding with implementation based on internal company policy. Option B. Implement the monitoring system with minimal employee notification, focusing only on the technical aspects of data collection and security, and deferring any discussion of privacy implications until a formal complaint is received. Option C. Conduct a comprehensive privacy impact assessment to evaluate the necessity and proportionality of the monitoring system, consult with legal experts on EU fundamental rights and data protection, and engage in transparent communication with employees about the system's purpose, scope, and data handling practices, while ensuring robust data security measures are in place. Option D. Immediately implement the monitoring system across all operations, citing potential productivity gains and security benefits as overriding justifications, and address any employee concerns on a case-by-case basis after implementation. Correct answer is C. Conduct a comprehensive privacy impact assessment to evaluate the necessity and proportionality of the monitoring system, consult with legal experts on EU fundamental rights and data protection, and engage in transparent communication with employees about the system's purpose, scope, and data handling practices, while ensuring robust data security measures are in place. Explanation. Governance review demonstrates that a multinational corporation operating within Alabama, which also has significant business interests in the European Union, is facing a complex ethical dilemma concerning the implementation of a new employee surveillance technology. This technology, while potentially enhancing productivity and security, raises serious concerns regarding the fundamental rights of its employees. The challenge lies in balancing the company's legitimate business interests with its obligations under the Charter of Fundamental Rights of the European Union, particularly concerning the right to privacy and data protection, which are applicable to its EU-based operations, and potentially to its Alabama-based employees if the technology's scope or data processing extends beyond U.S. borders in a manner that implicates EU law. The best approach involves a comprehensive assessment of the surveillance technology's impact on employee privacy, conducted in consultation with legal counsel specializing in both U.S. labor law and EU data protection and fundamental rights. This assessment should meticulously evaluate whether the proposed surveillance measures are necessary, proportionate, and justified in a democratic society, as required by Article 7, Respect for Private and Family Life, and Article 8, Protection of Personal Data of the Charter. It should also consider the principle of proportionality ensuring that the intrusion into privacy is the least intrusive means to achieve a legitimate objective. Furthermore, transparent communication with employees about the nature and purpose of the surveillance, along with the implementation of robust data security measures and clear data retention policies, are crucial steps. This approach prioritizes adherence to the Charter's principles by proactively identifying and mitigating potential infringements on fundamental rights, thereby demonstrating a commitment to ethical corporate conduct and legal compliance. An approach that prioritizes immediate implementation of the technology based solely on potential productivity gains, without a thorough privacy impact assessment or consideration of proportionality, fails to uphold the principles enshrined in the Charter. This would constitute a significant regulatory and ethical failure, as it disregards the fundamental rights of employees to privacy and data protection. Such an action could lead to legal challenges, reputational damage, and a breakdown of trust between the company and its workforce. Another unacceptable approach would be to dismiss the applicability of the Charter of Fundamental Rights of the European Union entirely, arguing that the company is primarily based in Alabama. This overlooks the fact that companies operating within the EU or processing data of EU citizens are subject to EU law, including the Charter. Ignoring these obligations is a direct contravention of legal requirements and demonstrates a lack of ethical responsibility. Finally, an approach that involves implementing the technology with minimal, superficial consultation with employees, without a genuine effort to address their privacy concerns or to ensure the measures are proportionate, also falls short. This superficial engagement fails to meet the spirit of transparency and respect for fundamental rights mandated by the Charter and ethical business practices. Professionals should adopt a decision-making process that begins with identifying all applicable legal and ethical frameworks. This involves understanding the scope of relevant regulations, such as the Charter of Fundamental Rights of the European Union, even when operating in a different jurisdiction. If cross-border data processing or operations are involved, the next step is to conduct a thorough risk assessment, focusing on potential infringements of fundamental rights. This should be followed by seeking expert legal and ethical advice. Crucially, transparency and meaningful consultation with affected stakeholders, in this case, employees, are essential. The final decision should be based on a demonstrable commitment to proportionality, necessity, and the least intrusive means to achieve legitimate business objectives, ensuring compliance with both legal obligations and ethical standards. Question 15. Governance review demonstrates a potential conflict of interest involving a senior executive at an Alabama-based company that operates subsidiaries within the European Union. The executive's spouse holds significant shares in a key supplier to one of these EU subsidiaries. What is the most appropriate course of action for the company to take in this situation? Option A. Immediately disclose the potential conflict of interest to the company's board of directors and the relevant compliance officer, and work with them to establish appropriate management protocols. Option B. Rely on the executive's personal assurance that their judgment will not be influenced by their spouse's shareholding and continue with business as usual. Option C. Wait until a specific contract or decision involving the supplier arises before addressing the potential conflict of interest. Option D. Consult legal counsel to determine the minimum disclosure requirements necessary to avoid regulatory penalties, without necessarily disclosing the full extent of the situation. The correct answer is A. Immediately disclose the potential conflict of interest to the company's board of directors and the relevant compliance officer, and work with them to establish appropriate management protocols. Explanation. Governance review demonstrates a potential conflict of interest involving a senior executive at an Alabama-based company that operates subsidiaries within the European Union. The executive's spouse holds significant shares in a key supplier to one of these EU subsidiaries. This situation presents a professional challenge because it blurs the lines between personal financial gain and corporate fiduciary duty, potentially compromising objective decision-making and the company's adherence to EU regulations concerning fair competition and transparency. Careful judgment is required to navigate the ethical and legal implications. The best professional approach involves immediate and transparent disclosure of the potential conflict of interest to the company's board of directors and the relevant compliance officer. This approach is correct because it aligns with fundamental ethical principles of honesty and integrity, and it directly addresses the potential for undue influence. Under Alabama corporate law and general principles of fiduciary duty, directors and officers owe a duty of loyalty to the corporation, which includes avoiding situations where their personal interests conflict with the company's interests. Proactive disclosure allows the board to implement appropriate safeguards, such as recusal from relevant decision-making processes or independent oversight, thereby ensuring that decisions concerning the supplier are made in the best interest of the company and in compliance with EU directives on public procurement and competition law, which emphasize impartiality and the avoidance of conflicts of interest. An approach that involves downplaying the significance of the shareholding and relying on the executive's personal assurance of impartiality is professionally unacceptable. This fails to acknowledge the inherent risk of bias, even if unintentional, and violates the duty of loyalty by not fully disclosing a situation that could reasonably be perceived as a conflict. It also disregards the spirit and letter of EU regulations that require robust conflict of interest management to maintain market integrity. Another unacceptable approach is to wait for a specific decision or contract negotiation involving the supplier to arise before addressing the issue. This reactive stance creates a higher risk of actual impropriety or the appearance of impropriety, potentially leading to regulatory scrutiny and reputational damage. It demonstrates a lack of proactive governance and a failure to uphold the highest ethical standards expected of corporate leadership. Finally, an approach that involves seeking legal advice solely on how to circumvent disclosure requirements, rather than on how to manage the conflict ethically and compliantly, is also professionally unacceptable. This indicates a disregard for ethical obligations and a potential intent to mislead or obscure the conflict, which is contrary to the principles of good corporate governance and the transparency expected under EU legal frameworks. Professionals should employ a decision-making framework that prioritizes transparency, ethical conduct, and regulatory compliance. This involves identifying potential conflicts early, disclosing them promptly to the appropriate authorities within the organization, and working collaboratively to implement mitigation strategies that protect the company's interests and uphold its legal and ethical obligations. Question 16. Compliance review shows that an Alabama judge, who previously practiced law in a small firm for several years before ascending to the bench, is assigned a case where opposing counsel is a former law partner from that firm. The judge believes their professional relationship ended amicably years ago, and that no lingering personal animosity or favoritism exists, nor does the judge believe their impartiality will be affected. However, the judge is aware that the opposing counsel's firm was known for its aggressive litigation tactics during their tenure. What is the most ethically sound course of action for the Alabama judge to take regarding this case? Option A. Inform the opposing counsel of the past association and ask if they have any concerns about the judge presiding over the case, relying on their response to determine whether to recuse. Option B. Conduct a thorough review of Alabama Rule of Judicial Conduct 2.7 and relevant Alabama case law concerning judicial recusal, objectively assessing whether the past professional relationship, even if amicable, could reasonably lead a member of the public to question the judge's impartiality, and if so, recuse themselves. Option C. Discuss the situation with other judges on the court to gauge their opinions on whether recusal is warranted and proceed based on the general consensus. Option D. Proceed with the case, confident that the past professional relationship is sufficiently distant and amicable to not influence their decision, and that their personal integrity will ensure a fair outcome. The correct answer is B. Conduct a thorough review of Alabama Rule of Judicial Conduct 2.7 and relevant Alabama case law concerning judicial recusal, objectively assessing whether the past professional relationship, even if amicable, could reasonably lead a member of the public to question the judge's impartiality, and if so, recuse themselves. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires balancing the duty to uphold the integrity of legal proceedings with the potential for personal relationships to influence professional judgment. The Alabama lawyer must navigate the complex ethical landscape of judicial recusal, where even the appearance of impropriety can undermine public trust in the justice system. The core tension lies in determining whether a past professional association, even if seemingly distant, creates a bias that necessitates recusal under Alabama law and ethical rules. Correct approach analysis. The best professional practice involves a thorough and objective assessment of the relationship's potential to create an appearance of impropriety or actual bias, leading to recusal. This approach directly aligns with the principles of judicial impartiality and the Alabama Rules of Judicial Conduct, specifically Rule 2.7, which mandates recusal when a judge's impartiality might reasonably be questioned. By proactively seeking guidance and considering recusal based on the past professional relationship, the judge demonstrates a commitment to upholding the integrity of the judicial process and adhering to the spirit and letter of Alabama's judicial ethics. This approach prioritizes transparency and the avoidance of any perception of unfairness, which is paramount in maintaining public confidence in the judiciary. Incorrect approach is analysis. One incorrect approach involves dismissing the past association as irrelevant without a formal assessment, relying solely on the belief that no actual bias exists. This fails to consider the objective standard of whether a reasonable person would question the judge's impartiality, as required by Alabama Rule 2.7. It overlooks the ethical imperative to avoid even the appearance of impropriety, which can be as damaging as actual bias. Another incorrect approach is to proceed with the case, while privately hoping the past association does not influence the decision. This is ethically unsound, as it places the burden of ensuring impartiality on the judge's internal, unscrutinized thoughts rather than on objective adherence to ethical rules and judicial precedent. It also fails to address the potential for the opposing party or the public to perceive bias, even if none is intended. A further incorrect approach is to consult with colleagues informally for their opinion on whether recusal is necessary, without independently analyzing the situation against Alabama's judicial conduct rules and relevant case law. While collegial advice can be helpful, it does not substitute for the judge's personal responsibility to make a reasoned decision based on established ethical standards and legal precedent. This approach risks relying on subjective opinions rather than objective legal and ethical requirements. Professional reasoning. Professionals facing such dilemmas should employ a structured decision-making process. First, identify the ethical and legal obligations relevant to the situation. In this case, Alabama's Rules of Judicial Conduct and any pertinent Alabama Supreme Court decisions on judicial recusal. Second, objectively assess the facts against these obligations, considering both actual bias and the appearance of impropriety from the perspective of a reasonable observer. Third, explore all available avenues for guidance, including formal ethical opinions or consultation with judicial ethics committees if applicable, but ultimately make an independent, reasoned decision. Finally, document the decision-making process and the rationale, especially if recusal is deemed unnecessary, to demonstrate due diligence and adherence to ethical standards. Question 17. Operational review demonstrates that a proposed development project in Alabama requires an environmental impact assessment. While the project scope has potential implications that align with considerations addressed by the European Union's Strategic Environmental Assessment Directive, the primary legal obligation for conducting this assessment falls under Alabama state law. Which approach best ensures compliance and effective environmental protection for this project within Alabama? Option A. Conduct the environmental impact assessment strictly in accordance with the Alabama Environmental Policy Act and its implementing regulations, utilizing the European Union's Strategic Environmental Assessment Directive as a source for supplementary best practices where they do not conflict with Alabama's legal requirements. Option B. Disregard the European Union's Strategic Environmental Assessment Directive entirely, focusing solely on the minimum requirements stipulated by the Alabama Environmental Policy Act to avoid any potential complications. Option C. Prioritize the European Union's Strategic Environmental Assessment Directive as the governing framework, assuming its provisions offer a more comprehensive standard that supersedes Alabama's state-level regulations for this project. Option D. Develop a blended assessment process that equally integrates requirements from both the Alabama Environmental Policy Act and the European Union's Strategic Environmental Assessment Directive, allowing for modifications to Alabama's standards where the EU directive suggests a different approach. The correct answer is A. Conduct the environmental impact assessment strictly in accordance with the Alabama Environmental Policy Act and its implementing regulations, utilizing the European Union's Strategic Environmental Assessment Directive as a source for supplementary best practices or they do not conflict with Alabama's legal requirements. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the imperative to comply with Alabama's specific regulatory framework for environmental impact assessments with the practical need to integrate findings from a broader European Union directive. Misinterpreting or misapplying the hierarchy of these legal instruments could lead to noncompliance with Alabama law, potentially resulting in penalties, project delays, or invalidation of the assessment. The professional must exercise careful judgment to ensure that the Alabama-specific requirements are met, while also considering the broader context provided by the EU directive, without allowing the latter to supersede the former where they diverge. Correct approach analysis. The best professional practice involves prioritizing the Alabama Environmental Policy Act, EPA, and its implementing regulations as the primary legal framework governing the impact assessment process. This approach necessitates a thorough review of the EPA to identify all mandatory procedural steps, content requirements, and substantive standards for assessing environmental impacts within Alabama. Findings from the European Union's Strategic Environmental Assessment, (C) Directive, can then be used as supplementary information or best practice guidance, particularly where they offer more rigorous analysis or address aspects not explicitly detailed in the EPA. However, any aspect of the EU directive that conflicts with or is less stringent than EPA requirements must be disregarded in favor of Alabama's law. This ensures absolute compliance with the governing jurisdiction's legal mandates while leveraging international best practices where appropriate and permissible. Incorrect approaches analysis. One incorrect approach would be to solely rely on the European Union's SEA directive for the impact assessment process, assuming its provisions automatically apply or are superior to Alabama's regulations. This fails to recognize that Alabama has its own distinct statutory framework, EPA, that dictates the legal requirements for environmental impact assessments within the state. Adopting this approach would constitute a direct violation of Alabama law, potentially leading to legal challenges and regulatory sanctions. Another incorrect approach would be to attempt to create a hybrid assessment that equally weights the EPA and the EU SEA directive, allowing elements of the EU directive to modify or dilute Alabama's specific requirements. This is problematic because it introduces uncertainty and a lack of clear legal grounding. The EPA is the operative law, and its requirements are not subject to amendment by international directives unless explicitly incorporated into Alabama legislation, which is not the case here. This approach risks noncompliance by failing to adhere strictly to the mandated Alabama process. A further incorrect approach would be to disregard the EU SEA directive entirely, assuming it has no relevance whatsoever. While Alabama law is paramount, the EU directive might offer valuable insights into methodologies or considerations that could enhance the quality and comprehensiveness of the impact assessment, provided they do not contradict EPA mandates. A complete dismissal might lead to a less robust assessment than could otherwise be achieved, potentially missing opportunities to identify and mitigate environmental impacts effectively, even if technically compliant with the EPA. Professional reasoning. Professionals undertaking environmental impact assessments in Alabama must adopt a hierarchical approach to legal compliance. First, identify and meticulously adhere to the specific statutory and regulatory requirements of Alabama, primarily the EPA. Second, review relevant international or other jurisdictional frameworks, such as the EU SEA directive, to identify potential best practices or supplementary analytical tools. Third, critically evaluate how these external frameworks align with or diverge from Alabama's legal obligations. Fourth, integrate any beneficial aspects of external frameworks only to the extent that they supplement, enhance, or are fully compatible with the EPA requirements, ensuring no conflict or dilution of Alabama's legal mandates. This systematic process guarantees legal compliance while promoting high-quality environmental analysis. Question 18. Cost-benefit analysis shows that a proposed Alabama state environmental regulation concerning agricultural runoff could impose significant compliance costs on individual farmers. However, the regulation aims to address widespread water quality degradation impacting multiple counties. Which of the following approaches best upholds the principle of subsidiarity in this context? Option A. Proceed with the state-level regulation. As the environmental issues' transboundary nature and potential for widespread impact justify state intervention to ensure uniform protection of water resources across Alabama, even with associated costs. Option B. Focus solely on the economic burden of the regulation, concluding that the costs outweigh the benefits and therefore the state should not act, regardless of the environmental problem scope. Option C. Implement the state-level regulation, but waive all compliance costs for farmers, prioritizing local economic concerns over the environmental objectives. Option D. Reject the state-level regulation and leave the matter entirely to individual county governments, assuming they can independently and effectively manage the complex issue of agricultural runoff within their borders. The correct answer is A. Proceed with the state-level regulation, as the environmental issues' transboundary nature and potential for widespread impact justify state intervention to ensure uniform protection of water resources across Alabama, even with associated costs. Explanation. Scenario analysis. This scenario presents a professional challenge in interpreting and applying the principle of subsidiarity within the context of Alabama's legislative process, specifically concerning a proposed environmental regulation. The challenge lies in determining whether the proposed state-level regulation infringes upon the authority of local governments, or if it appropriately addresses an issue that transcends local boundaries. Misinterpreting subsidiarity could lead to inefficient governance, overreach by one level of government, or failure to address environmental concerns effectively. Careful judgment is required to balance state authority with local autonomy, ensuring that regulations are enacted at the most appropriate level. Correct approach analysis. The best professional approach involves a thorough assessment of the proposed environmental regulation against the principle of subsidiarity as understood within Alabama's legal framework. This entails evaluating whether the issue the regulation seeks to address can be effectively managed by local governments within their respective jurisdictions. If the environmental problem has cross-jurisdictional impacts, requires uniform standards across the state, or if local governments lack the resources or expertise to address it adequately, then state-level intervention is justified. This approach aligns with the principle of subsidiarity by ensuring that decisions are made at the lowest effective level of government, reserving state action for issues that necessitate it. The justification rests on the core tenet of subsidiarity, that a higher level of organization should not interfere with a lower level unless the lower level is incapable of effectively addressing the matter. Incorrect approaches analysis. One incorrect approach would be to automatically defer to local control without considering the nature and scope of the environmental issue. This fails to acknowledge that some environmental problems, such as widespread pollution or watershed contamination, inherently transcend local boundaries and require a coordinated state-level response. Another incorrect approach would be to assume that any regulation proposed by the state automatically supersedes local authority, regardless of whether the issue could be effectively managed locally. This disregards the principle of subsidiarity by potentially overreaching state power and undermining local governance. Finally, an approach that focuses solely on the cost of implementation without considering the necessity and effectiveness of state intervention would be flawed. While cost is a factor in any policy decision, it should not be the primary determinant when evaluating the application of subsidiarity. Professional reasoning. Professionals should approach such situations by first clearly defining the problem the regulation aims to solve. Then they must analyze the geographical scope and impact of the problem. This analysis should consider whether local governments have the capacity, resources, and legal authority to effectively address the issue. If the problem is localized and manageable by local entities, state intervention may not be necessary. However, if the problem is widespread, has transboundary effects, or requires uniform standards for public health and environmental protection, then state-level regulation is likely appropriate under the principle of subsidiarity. This systematic evaluation ensures that regulatory action is taken at the most effective and appropriate level of governance. Question 19. Strategic planning requires a member state of the European Union to consider the implications of its proposed national legislation on the Union's foundational principles. For a member state like Alabama, which is part of the United States and has a specific legislative proposal aimed at streamlining its internal market regulations, what is the most appropriate method to ensure this legislation aligns with the Treaty on European Union 2? Option A. Conduct a comprehensive impact assessment that specifically evaluates the proposed legislation's compatibility with the objectives and values outlined in Articles 2 and 3 of the Treaty on European Union, considering potential effects on the rule of law, human rights, and the functioning of the internal market. Option B. Prioritize the immediate economic advantages of the proposed legislation, assuming that any economic benefits will inherently align with the broader goals of the European Union. Option C. Rely on informal discussions with officials from other EU member states to gauge their general sentiment towards the proposed regulatory changes, without a formal analysis of treaty compliance. Option D. Focus primarily on national sovereignty, interpreting the TEU as a framework that allows for unilateral decisions, as long as they do not directly contradict explicit prohibitions within the treaty. Correct answer is A. Conduct a comprehensive impact assessment that specifically evaluates the proposed legislation's compatibility with the objectives and values outlined in Articles 2 and 3 of the Treaty on European Union, considering potential effects on the rule of law, human rights, and the functioning of the internal market. Explanation: this scenario is professionally challenging because it requires a nuanced understanding of how the Treaty on European Union, TEU, provisions, particularly those related to the Union's objectives and values, translate into practical policymaking within a member state. The challenge lies in balancing national interests with the overarching commitments made under the TEU, ensuring that legislative proposals do not inadvertently undermine the foundational principles of the EU. Careful judgment is required to assess the potential impact of proposed legislation on the EU's legal order and its shared values. The correct approach involves a thorough impact assessment that specifically analyzes the alignment of the proposed legislation with the objectives and values enshrined in the Treaty on European Union, particularly Articles 2 and 3 TEU. This approach is correct because it directly addresses the legal and ethical obligations of an EU member state by systematically evaluating how the proposed law upholds or potentially conflicts with principles such as democracy, the rule of law, human rights, and the internal market. It ensures compliance with the foundational treaty. This proactive assessment allows for the identification of potential issues early in the legislative process, enabling amendments to ensure compatibility with EU law and values, thereby fulfilling the member states' obligations under the TEU. An incorrect approach would be to focus solely on the immediate economic benefits of the proposed legislation, without considering its broader implications for EU values. This fails to acknowledge the interconnectedness of economic policy with the fundamental principles of the Union, as outlined in the TEU. Such a narrow focus risks creating legislation that, while perhaps economically advantageous in the short term, could lead to legal challenges or political friction due to its incompatibility with core EU commitments. Another incorrect approach would be to prioritize national sovereignty concerns above all else, dismissing any potential impact on EU law as secondary. While member states retain significant powers, the TEU establishes a framework of shared competences and mutual obligations. Ignoring the potential for conflict with EU law, as established by the TEU, can lead to infringement proceedings and undermine the integrity of the EU legal order. This approach disregards the principle of sincere cooperation and the binding nature of treaty obligations. Finally, an approach that relies on informal consultations with other member states without a structured impact assessment is insufficient. While dialogue is valuable, it cannot replace a rigorous, documented analysis of how the proposed legislation aligns with the TEU. Informal discussions may not capture the full scope of potential legal or ethical issues, nor do they provide the necessary justification for legislative choices in relation to EU commitments. Professionals should adopt a decision-making framework that begins with a clear understanding of the relevant EU legal framework, particularly the TEU. This should be followed by a comprehensive impact assessment that scrutinizes the proposed legislation against the objectives and values of the Union. Where potential conflicts are identified, the framework should guide the process of amendment or reconsideration to ensure compliance. Transparency and documentation of this assessment process are crucial for accountability and demonstrating adherence to EU obligations. Question 20. The monitoring system demonstrates a potential cartel agreement among manufacturers of specialized electronic components in Germany that may restrict competition. To assess the potential impact on the market, an economic analysis is being considered. If the agreement is estimated to cause an average price increase of 15% on a product with an initial price of Euros 100, leading to a 10% reduction in sales volume from an initial 1,000,000 units, and assuming a linear demand curve and constant marginal costs, what is the approximate deadweight loss in euros, representing the loss of economic efficiency? Option A, Euros 15,000,000. Option B, Euros 7,500,000. Option C, Euros 1,500,000. Option D, Euros 5,000,000. The correct answer is B, Euros 7,500,000. Explanation: the monitoring system demonstrates a potential infringement of Article 101 TFU concerning anti-competitive agreements. The scenario presents a professionally challenging situation because it requires a nuanced understanding of economic analysis and its application to competition law, specifically within the framework of the Treaty on the Functioning of the European Union (TFU). The challenge lies in accurately quantifying the potential impact of the agreement on competition and consumer welfare, which is crucial for determining the severity of the infringement and potential remedies. Careful judgment is required to distinguish between legitimate business practices and those that restrict competition. The approach that represents best professional practice involves a rigorous economic assessment of the agreement's effects on the relevant market. This includes calculating the potential loss of consumer surplus and producer surplus, as well as estimating any potential efficiency gains that might offset the anti-competitive effects. Specifically, this approach would involve using established economic methodologies to quantify the deadweight loss resulting from the agreement. For instance, if the agreement leads to a price increase from /P0 to /P1 and a corresponding decrease in quantity from /Q0 to /Q1, the deadweight loss can be approximated by the area of the triangle formed by the demand curve, the supply curve or marginal cost, and the change in quantity with a height of /P1 P0 /. This detailed economic analysis is correct because it directly addresses the TFU concern with the effects of agreements on competition and consumer welfare, as outlined in Article 101(1), and the principles of proportionality and necessity in Article 101(3). It provides an objective, data-driven basis for assessing the infringement. An incorrect approach would be to solely rely on the existence of the agreement without quantifying its actual or potential impact. This fails to acknowledge that not all agreements between undertakings are prohibited, and Article 101(3) TFU allows for exemptions if certain conditions are met, which often involve a balancing of anti-competitive effects against pro-competitive benefits or efficiencies. Another incorrect approach would be to focus only on the potential for increased profits for the parties involved, without considering the broader market impact and consumer welfare. This overlooks the core objective of competition law, which is to protect the competitive process for the benefit of consumers and the economy as a whole. A further incorrect approach would be to make a qualitative assessment of the agreement's restrictiveness without any quantitative economic analysis. While qualitative factors are important, a robust impact assessment requires quantitative evidence to support conclusions about the degree of restriction and potential harm. The professional reasoning process for such situations should involve a systematic evaluation of the agreement's characteristics and its likely effects on the relevant market. This begins with defining the relevant product in geographic markets. Subsequently, an economic analysis should be conducted to assess the agreement's impact on prices, output, innovation, and consumer choice. This analysis should consider both actual and potential effects, and where possible, quantify these effects using appropriate economic models and data. The findings of this economic assessment should then be weighed against any claimed efficiencies or pro-competitive benefits, in accordance with Article 101(3) TFU. This structured approach ensures that decisions are based on sound economic principles and are consistent with the objectives of EU competition law.